I'm very happy to be here, and I am hoping that you will find this interesting and informative. And if you have suggestions on how to make it entertaining, I'm open to them. So what I'm going to be talking about today is secularism in Canada, which is government neutrality in matters of religion, and sort of talk about where we were, where we are, and possibly where we're headed. So for the last dozen years or so, I've been involved when I'm not working, parenting, or sleeping in two areas of activism. And one is to try and promote cultural change. And through that, I have been a volunteer for the Center for Inquiry almost since its inception. I found out about it through a podcast and joined pretty much right away. Center for Inquiry Canada, if you don't know, it's an educational charity, and it supports reason, science, and secular values. And that's certainly something that resonates with me. I'm also interested in legal and institutional change. And for that reason, I'm a founding member of and policy advisor for the Canadian Secular Alliance. It's a nonprofit think tank, an advocacy organization, and we're looking at church-state separation and neutrality of government neutrality in matters of religion. So if I'm going to be talking about secularism, it's a word which has many definitions. So I think it's important that I start off by giving you the definition of secularism as I understand it and as I'm going to be using it for the next several minutes. And that is, it's the principle of government neutrality in matters of religion. Government should not favor one religion over any other, or privilege religious belief over non-belief. Or to put it another way, the government of Canada should neither support nor suppress religious expression amongst its populace. And this is the definition, this is political secularism. It's the definition that I use when I talk about secularism. It's also the one used by the Center for Inquiry and the Canadian Secular Alliance. So I also, should probably tell you what secularism is not. So a valid use of the word, but not the way I'm going to be using it, is complete church-state separation. Now, that is the way secularism is understood, particularly from in France and Quebec. And it's a valid use of the word, but not the way that I'm using it today. When you take those two different definitions and then apply them in most practical circumstances, you're about 95% of the time, you're going to come to the same conclusion. But from different premises, sometimes you come to different conclusions. And there are times when those two different definitions result in different stances on various issues. I'm not talking about secularism, as it also is often used, as the extent or a reduction of religious belief or practice in society. So you often read newspaper articles about a society becoming more secular. And what they mean by that is that church attendance is down, or that the number of nuns in some survey is going up. It's a valid use of the word, not what I'm going to be talking about today. And sometimes it's used as a pejorative. This is usually from a representative of a religious organization complaining about anti-religious bias. And that's not what I'm using the word. That's not what I mean when I use the word in today's presentation. So let's go right into secularism today and secularism in practice. Canadians, we tend to like to keep politics and religion separate. If someone wears their faith on their sleeve, it's generally deemed to be somewhat gauche. It's fine to be whatever it is that you like, but we tend not to be too overt about it. We have more concern as a society about politicians being too religious or rather than being insufficiently observant. And this is why sometimes in campaigns with the mudslinging that happens during elections, there are accusations of being a closet creationist or having a hidden agenda more than anything else. in the United States, they've had one Catholic president, which was Kennedy. When he was elected, there was a big concern about where his loyalties lay. Was it to the United States or was it to the Pope? In Canada, we don't really worry about such things. And the closest example I could think of in Canada is kind of a faux controversy we had a few years ago about some politicians having dual citizenship. So we don't have any new laws being introduced in the last several decades that have an explicitly religious justification. Any laws, regulations, or policies that are introduced are given, broadly speaking, rational justifications, even if they are inspired by faith. And this goes right back to Medicare way back. That's not protection, of course, against nepotism or other forms of corruption, but at least we don't have religious justifications for our laws. Now, if we contrast that with the United States, religion and faith play an enormous, and I would argue, outsized role in politics and elections. I don't think that there is a politician in the United States that doesn't end any public address, or they end every public address, that is, with "God bless America." There's the objection to major public policies in the United States often have solely a religious reason for it. So just to pick a couple examples, same-sex marriage and objections to abortion are based solely and explicitly in religion. And it's an affront upon God to have two men or two women live together, or to get married, or have the state endorse such unions. As is the scientifically false contention that life begins at conception and therefore abortion is murder. There are theoretically or in principle secular arguments against abortion. I personally don't agree with them. They exist. They are never employed in public discourse in the United States. But in the United States, 7 state constitutions explicitly ban atheists from public office. It's been written right into the constitutions and of 7 different states, and those terms are still there today. Now, I should also point out that those terms are null and void. They were unenforceable because of a U.S. Supreme Court decision dating back to the 1960s. But practically speaking, it is nearly impossible for an atheist, an open atheist, to get elected in the United States. Now, if we look at secularism in theory, the states notwithstanding, the states' constitutions notwithstanding, the United States formally is actually extremely secular. The Supreme Court rendered null and void those terms in state constitutions. The actual founding document, the Constitution of the United States, Article 6, says no religious test shall ever be required as a qualification to any office or public trust under the United States. The First Amendment, which is probably even more well-known, says in part that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So these are wonderful secular principles. And so if you just looked at the United States on paper, you would think that it would be a far more secular country than it is in practice. Canada, not so much in theory. We have the supremacy of God, and right there in the preface, in the first sentence of our Charter of Rights and Freedoms, which is Canada's equivalent of the Constitution. God keep our land glorious and free is a line prominent in our national anthem. And we have publicly funded school systems, and these are constitutionally guaranteed in today's Canada in 3 provinces: Ontario, Alberta, and Saskatchewan. So how secular was Canada? And this is going back to I'm talking about at its founding. What was Canada like when we started as a country? And the answer is not at all, not even a little of it. We inherited Christian laws and institutions from England and France, and those institutions and laws have been protected quite vigorously by those that benefited from it. When we were founded as a country, really only white Christians were deemed to be real Canadians. And that toxic mix of racism and religious bigotry is a big stain on the origin of our country. One example is that the Chinese workers who worked on our national railway, one of the major country building projects at the outset of our nation, they were considered dispensable. They were given all the most dangerous jobs. The fatality rate among those workers was much higher, and they were paid roughly half what the white workers were given. Also, even before Canada was founded as a country, we had residential schools because European settlers were not the first people to live on the land, and the numerous Indigenous nations were forced to go to residential schools. And this was with the explicit purpose to make the Indigenous peoples of Canada embrace Western values and Christianity. Morality and the Christian faith were deemed synonymous. And the goal of these residential schools was, again, quite explicitly to civilize the savage through Christianization. This was horrific government policy that was enthusiastically executed largely by the Christian churches of the country. And it is a legacy that we're still living with today. And what surprised me was I learned not very long ago that the last residential school in Canada closed only in 1996. So that's not very long ago at all, given our country's history. And there's also the Duplessis orphans, also known as the children of sin. Under Quebec Premier Maurice Duplessis in the 1940s and 50s, children that were born to unwed mothers were forcibly sent to Catholic orphanages, usually within 3 days of birth. The Duplessis and the church, Catholic Church that is, to be specific, then reclassified these orphanages as psychiatric hospitals because under Quebec law at the time, they would get this would more than double the daily stipend. They were the children that were otherwise healthy children that were in these hospitals were neglected and abused. The Quebec government in 2006 offered a $26 million settlement to survivors of these institutions. But anyone that agreed to this compensation had to sign a waiver declaring they would not take legal action, not against the Quebec government, but against the Catholic Church. So this is, there are many stains on our country's history. So moving on to more recent history, in 1982, we brought into effect the Charter of Rights and Freedoms. And as I mentioned before, the preamble includes the supremacy of God. Now, I just want to give you a couple of quotations from the Prime Minister of the time, Pierre Trudeau. He said in an interview after the fact that he thought it was, and these are direct quotations, strange so long after the Middle Ages that some politicians felt obliged to mention God in a constitution, which is, after all, a secular and not a spiritual document. He also said, in what I can only imagine was in a fit of pique, I don't think God gives a damn whether he's in the Constitution or not. So I think it's interesting that that particular part of our Constitution did not have, shall we say, the full support of the Prime Minister at the time, but it was a compromise that for whatever reason he felt was necessary. But the supremacy of God is problematic for other reasons. It's contradicted by Section 2 of the Constitution, which gives freedom of conscience and religion, as well as thought, belief, opinion, and expression. So if God is supreme, then if you believe in many gods or none at all, then you're not really recognized within the country. The full preamble reads, and I'll quote the whole thing, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. So it's also a little bit confusing, and it's never really been resolved formally, which is supreme, God or the rule of law. One thing that I've noticed is that supremacy doesn't like to be shared. The good news, however, is that whereas the preamble is symbolically significant, successive Supreme Court rulings give it very little legal weight. So I want to talk about a few, I think, relevant Supreme Court rulings over the years since the charter has been established that hopefully will be of interest to you. So in 1995, a case made it to the Supreme Court about Ontario's Sunday shopping law. And the result was that they struck down what was called the Lord's Day Act. And the reasoning was that this was a law designed to protect one religion. So the defense that Ontario mounted, among other things, was saying, but we just want a common day of rest. This is a good thing. People don't have to work 7 days a week. It's not good. For the people we're protecting the workers of the province. This was rejected by the Supreme Court. The law mandated that it had to be Sunday. I'm sure that that's the Christian Sabbath was completely coincidental. But they did not allow substitution. So if you are an observant Jew, for example, you couldn't close your shop on Saturday and then stay open on Sunday. You still had to be open on Sunday. So it wasn't really about a day of rest. And also, it was actually called the Lord's Day Act, which made it clear that the intention behind the act was not a secular purpose. So it was struck down. The Supreme Court did leave open the possibility of legislating stores to be closed on one day of the week. It was not that principle that was rejected, but over the last nearly 40 years, various provinces have, since any efforts to establish mandatory closings of retail, have either failed or been abandoned. But one quotation from the judgment that I think is quite relevant and echoes even to this day is that non-belief is equally protected under religious freedom. So this, I think, to my knowledge, is the first time this statement was formally made part of Canadian jurisprudence. Then there was a case a few years ago that made its way to the Supreme Court about prayer before municipal council meetings. A city in Quebec had a particularly observant mayor, Jean Tremblay, and he started every meeting with a prayer, always Christian, usually explicitly Catholic. There was an atheist that lived in that municipality who was politically active and attended meetings and felt very uncomfortable and asked the mayor to stop. The mayor's response was, well, if you're uncomfortable while we pray before a meeting in the hall where they were held, then you can leave the room and then just come back when the prayer is done. And so he did not accept that, and so he sued, and this made its way to the Supreme Court. The Supreme Court ruled that municipalities are barred from engaging in public prayer. You can be whatever faith you want. You can pray as much as you want in private, but you're not to use the instrument of government. You're not to start a formal public meeting with a prayer. And the rationale for that was that that the government cannot be seen to endorse any particular faith. So, and I think I'm going to share a couple quotations because, again, I think that these are relevant. Supreme Court judgments are binding precedents on the entire country, and so it's really important the words that are in the judgment. So, the sponsorship of one religious tradition by the state in breach of its duty of neutrality amounts to discrimination against all other such traditions. The judgment also said, in short, there is a distinction between unbelief and true neutrality. True neutrality presupposes abstention, but it does not amount to a stand favoring one view or another. No such inference can be drawn from the state's silence. And I think that's really important. So what the court is saying here, what the court has said here, is that by saying nothing, we are not endorsing atheism. We're just silent on the topic. And if we're silent on the topic, that's not an endorsement of atheism. It's not an endorsement of any faith. It is neutrality. So that's, I think, a really important concept that is now part of Canadian jurisprudence. They also wrote about the preamble of the Constitution. The preamble cannot lead to an interpretation of freedom of conscience and religion that authorizes the state to consciously profess a theistic faith. So again, building on the protection of non-believers in addition to equally to believers, the fact that we have supremacy of God in the preamble of the Charter does not mean that Canada is a theistic state. Again, it's about neutrality. So this is, I think, really important. And then there was the Trinity Western case. Now, I'm going to struggle to be brief about this. I was really heavily involved. Oh, I should also say, sorry, before I move on to the next one, I am proud to say that the Canadian Secular Alliance, an organization that I'm active in, was an intervener at the Supreme Court in this case. And we argued for a secular approach, and I am delighted that the court ended up ruling along secular principles. So this was, I think, a tremendous victory for our organization, both to be recognized by the court, to be a valid organization to speak before them, and also that their ruling reflected not our words but the principles that we espoused. So this was, I think, a tremendous victory. I will try not to talk too long about Trinity Western, but I can get into a lot of detail about this. So Trinity Western University has been around for decades, and it is an evangelical Christian institution in British Columbia. It wanted to open a law school. It went through all of the procedures. It got a curriculum that was approved, and so it was going to open. All students at the university, including prospective law students, have to sign a community covenant. This was mandatory. It's about a 7-page document, and among its many provisions is a ban on sexual intimacy except between married couples, where a married couple is between a man and a woman. So the law societies of British Columbia, Ontario, and Nova Scotia saw this covenant and said, this is beyond the pale. This type of discrimination is unacceptable. And we will not accept your graduates. You can get a degree, you can get a law degree from Trinity Western, but you will not be able to practice law in our provinces. And Trinity Western said, well, that's not your business. Our curriculum is fine. And our community covenant is religious freedom, which is a charter right. And so you're infringing our freedom of religion by not accepting our graduates. And so they sued the 3 law societies, and this went all the way to the Supreme Court of Canada. So again, the Secular Alliance was involved in the Court of Appeals in all 3 provinces as an intervener, as well as an intervener at the Supreme Court. There's a lot of subtleties to this case, but what the ruling was that freedom of religion does not grant you the right to discriminate. So the harm caused to LGBT students who would not be able to, who would be forced into celibacy while a law student at Trinity Western is a grievous harm. And so even though you have a charter right to freedom of religion, which I think is a good thing, that does not give you the right to discriminate, to cause harm against others. So the freedom of religion includes freedom from religion. And I want to, again, give a few quotations that I think are going to resonate for decades to come, because this is really important stuff. The Charter does not protect measures by which an individual or faith community seeks to impose adherence of their religious beliefs or practices on others who do not share their underlying faith. That is, I think, a tremendous statement to have as a Supreme Court judgment. You can believe what you want. You are not allowed to force it upon others. It's explicit. It's wonderful. Even the minority view, and these are the folks that sided with Trinity Western in the case. It was a 7-2 ruling, but even the two judges who sided with Trinity Western had this to say: secularism connotes pluralism and respect for diversity. They also wrote, secularism guarantees an inclusive public sphere by neither privileging nor silencing any single view. The secular state is a neutral state, and they also reiterate that state neutrality must prevail. And I'll also just boast for a moment that one of the judges in a concurring opinion actually quoted the Canadian Secular Alliance submission, saying that the charter is a shield designed to protect people and cannot be used as a sword to attack others. So that was quite flattering. All right, quick quiz. Canada had a blasphemy law and it's been repealed. Do you know when Canada repealed its blasphemy law? And I want to include this because I want to show you that we don't always have to appeal to the courts to effect change. So Section 296 read that everyone who publishes a blasphemous libel is guilty of an indictable offense and liable to imprisonment for a term not exceeding 2 years. Now, you might not know the answer, so I'm going to give you a hint. The last conviction under this law was in 1927, and the last time it was invoked was in 1979 in an attempt to censor Monty Python's Life of Brian. So given that the law was effectively defunct, you might wonder why its eventual repeal was a milestone to be celebrated. Well, there's several reasons for this. There's some moral reasons. One is that immigrants to the country are very aware of our laws, and several of them are fleeing religious prosecution from their homelands. And when they see that Canada has a blasphemy law on the books, they are intimidated and frightened to actually speak their minds about religion if they happen to be critical. And that leads us, so that's a very real suppression of free speech. And that leads to the next moral reason why it's good that the law is off the books. And that's because just because governments haven't used it in quite a while doesn't mean that the next one won't, or that it can't be invoked tomorrow. So by having it off the books, it prevents a future government from trying to enforce an inherently unjust law. And the third reason is that other countries such as Pakistan and Saudi Arabia pointed to Canada, saying, yes, we put blasphemers to death, you put them in jail. They're using Canada as essentially a moral shield for their own unjust laws, and we should not allow them to do that, and we don't allow them to do that by taking the law off our books. There's also a practical reason, and that is that having and the reason for that, then the practical reason is the history of how this law got to be repealed. So when convicting a man of murder, an Alberta judge cited a section of the criminal code that the Supreme Court had previously declared to be unconstitutional. These are generally known as zombie laws. They're no longer in effect, but they're still on the books. So in response to this embarrassment, because that gave immediate grounds for appeal by citing a law that was null and void, the federal justice minister of the time announced a review of the criminal code. So with that, the Canadian Secular Alliance, the Centre for Inquiry Canada, and Humanist Canada arranged for a meeting with the senior bureaucrat of the Justice Department in charge of this file. And we brought Canada's blasphemy law to his attention and argued that while this particular section of the criminal code had not been tested by the courts, it almost certainly would be found to be unconstitutional. So a few months later, a bill was introduced that removed all zombie criminal code provisions. And we were a bit disappointed by that because the blasphemy law was not a zombie law. It was defunct, but not ruled unconstitutional already. But fortunately, a few months later, a second bill was introduced that promised to repeal Canada's blasphemy law and other provisions that would probably be found to be unconstitutional. And that included challenging somebody to a duel, fraudulently pretending to practice witchcraft, and impersonating somebody during a university exam. So to answer the question, when did Canada repeal its blasphemy law? The correct answer is December 13th, 2018. So this is really quite recent. So there's lots of secular debates happening in Canada today. One is medical assistance in dying. And what I want to point out is just how much the quality of the debate has changed in just a couple of years. Excuse me. When the law was introduced, the debate was primarily about whether people could have any say about how much they suffer before they die, or whether the religious view that life is sacrosanct and that man should not play God by murdering people, and those, like, which one of those viewpoints should dominate. We passed the medical assistance in dying, and today the debate continues, but its terms have shifted. Primarily, the public debate today is about what are the appropriate conditions for a person to be eligible for assistance in dying? When can we say that someone can start the process? And then also what the proper procedures are and timing when someone decides to end their life. So the law is under review. It's being challenged in the courts, but the fundamental terms of the debate have changed, in my view, for the better. It's now far more evidence-based and rational. There's also a more timely one, was a recent controversy about RCMP officers having to wear N95 respirator masks. And this is not possible to get the seal required for a respirator mask when you have a large beard. And the RCMP has a fair number of Muslim and Sikh officers that do have large beards, and for some of them, the facial hair is a religious requirement. And the RCMP said anyone that does not wear a respirator mask is going to be relegated to desk duty. So this seems superficially reasonable. And so you could take a stance that they could either shave and have their regular duties, or be on desk duty. And one could take a, potentially argue for a secular approach that this is required in the times of a pandemic. But if you dig a little deeper, that's not quite the truth. A policy requiring masks in times of COVID-19 is eminently reasonable, but the requirement for an N95 respirator mask is not necessary and is not supported by the evidence. There are very few situations in where a respirator mask is necessary for people's protection. And that's when you're going to have incredibly close contact, like intubating someone in a medical scenario. It's simply not required for almost any interaction that a police officer is going to have with the public for a respirator mask to be necessary. So the policy was amended so that masks are necessary and people with beards can wear masks effectively, but it didn't have to be this particular type of mask. And so it is important when taking a secular approach that even if the language or the rhetoric isn't one of targeting a particular group, that you take a look at what the requirements are and what the justifications are, and see if they can be tweaked to mitigate the impact if it happens to have a disproportionate impact on a particular group, which in this case were a couple of religious minorities. And then we have what is probably the most contentious debate within secular circles in Canada today, and that's the one about Quebec's secularism law, otherwise known as Bill 21. Among its numerous provisions that it bans the wearing of religious symbols by certain civil servants. And this is a debate that could probably fill the entire time for today. I'll just say that myself and both the Centre for Inquiry Canada and the Canadian Secular Alliance are against the bill, but I'm certainly aware that many secularists and some secular-minded organizations are staunchly in favor of it. As soon as the bill passed, there were two legal challenges that were launched. One was on the fundamental constitutionality of the law, which is a long and slow process. And one was a request for an emergency stay. So the emergency stay was a request that while we determine whether this is legal or not, please don't apply, please stop the provisions from applying so it doesn't come into effect. So that went up to the Quebec Court of Appeals, and they ruled 2-1 against that motion. So they said that it will come into effect and is binding upon the province while the constitutional challenge winds its way through the courts. And the Supreme Court did not hear the appeal to that. So we have to wait for the final one. But I do want to quote from one of the judges in that Court of Appeal, and they wrote, "The notwithstanding clause dictates that at this stage of the case, the courts must abandon to their fate women graduates who are willing to work and who, for the sole reason that they wear the veil," which is the hijab in this case, "have been denied access to a job for which they hold all the skills." That's translated from the French. The Quebec Superior Court is scheduled to hear the constitutional challenge next month. So we'll be keeping a close eye on that. And when it makes its way to the Supreme Court, the Secular Alliance is going to apply to be an intervener in that case as well. So there is still more work to be done. I think if George Orwell were alive and living in Canada today, he'd probably get government subsidies. Why do I say that? The Catholic school systems remain in 3 provinces. These are direct subsidies for religious indoctrination or religious faith instruction to the tune of billions of dollars every year. Advancement of religion is a charitable purpose. So if you do nothing but advance religion that is proselytized, you can count as a charity. You do not have to educate the ignorant, feed the poor, clothe the naked. Those are charitable activities. All you do is evangelize. In Canada, you're a charity. So the Centre for Inquiry Canada wrote a report on the cost of religion in Canada. It's the first of a series. It focused on this particular part of our tax system, and we estimate that it's probably $3 billion a year that is subsidized through tax credits for evangelical activities, which is not exclusively but overwhelmingly Christian in nature. There's a housing tax deduction for clergy, which is not available to anybody else. And places of worship and lands used in connection with them are exempt from property taxes, which again is a huge subsidy to I would estimate in the billions of dollars. The Centre for Inquiry Canada will be releasing reports analyzing the numbers of these in 2021, so stay tuned. And we also, as I mentioned before, have God in the Charter and the national anthem. But I want to, and I'm coming to the end here, I want to show how much Canada has changed in just 80 years. It makes a huge difference. So here we have 1939. There were more than 900 Jewish refugees fleeing Nazi Germany. They were denied entry in Cuba, the United States, and Canada, and were sent back. They were sent back to Europe. Canada had a policy when it came to Jews fleeing Nazi persecution of none is too many. And over the course of the Holocaust, so 1933 to 1935, Canada accepted the fewest number of Jewish refugees of any country in the world that accepted refugees at all. There were about 5,000 or so over the course of those dozen years. And then, but if you fast forward 80 years, we have the Prime Minister saying that Canadians will welcome you regardless of your faith. Diversity is our strength. And nearly 60,000 Syrian refugees have been accepted by Canada in the last 5 years or so. So there are two pillars of secularism, and it is important to keep them largely in balance. They move together, the legal and institutional. So these are the laws, the regulations, and the rules, and the cultural. And that's what people's expectations are. They need to move together. One can lead the other, but not by too much. If the gap gets too large between these two, it tends to snap back. And so we have to go with piecemeal, and they can leapfrog. And I think an excellent example of that is the story of equal marriage in Canada. This was banned by the law and was really a taboo for a long time. Decades of grassroots activism led to a lessening of societal taboo on homosexual relationships. But in a story of why religious freedom is important, the first same-sex marriage in Canada took place in a church. They essentially used a loophole that people could get married by a reading of the banns. And so they did that, which circumvented the law barring same-sex marriages. This was done to marry two men, and that opened the floodgates. Within a few years, 8 provincial courts mandated that we should recognize same-sex marriages, and then the federal government passed a law that did so in 2005. At the time when the law passed, Canadians were roughly equally divided on whether they supported or opposed same-sex marriages. And a decade and a half later, over 3/4 of Canadians support it. So progress is made. So there's lots of avenues to advocate for change. There's the courts, there's passing of the laws, and then there's cultural change as well. But if you've stayed with me for this long, thank you, because I recognize that I am incredibly wonky about this. And ultimately, secularism is boring. I view secularism as sort of societal infrastructure. And when it's working well, it should be invisible. Nobody cares about our water system or our electricity grid, except when it fails. When it's working well, you turn on a light, you turn on the tap, water comes out, the light goes on, and you don't think about it. That's how secularism should be. And government neutrality is something that everyone, even if they're being selfish, should support. Political secularism is the compromised position that ensures maximal freedom for all. When applied consistently, this prevents discrimination against members of a particular faith. It prevents favoritism towards members of one specific sect to the detriment of others, and it avoids treating non-believers differently than others. And why should you support it? Well, because in a pluralistic society like Canada, you're probably a member of some sort of minority. So you don't want the government to support just the majoritarian view or just one particular view. But even if you're part of the currently favored group, you might fall out of favor. Someone else might take power, and you don't want the next government, to have the power to use whatever favoritism that you enjoy today for that to be used against you and in favor of someone else tomorrow. The principle of treating everyone equally at all times is your best protection, not just today, but tomorrow and down the road, that you won't be targeted either. So it's really a position that I think non-believers, doubters, and believers of all stripes should support. So if you're still listening and you found all of this interesting, well then, gosh, are you gonna love my blog? Because I've got probably 50 or 60 essays on this topic and others at opinionsquestions.blogspot.com. So thank you very much for sharing half an hour, 40 minutes or so of your Saturday morning with me. And if there's any questions or discussion, I'm happy to talk further.
Okay, thank you very much, Leslie Rosenblood. Now, please, everyone, take your mute microphones off mute and give Leslie a round of applause for what he's done this afternoon.
Thank you. Thank you.
That's fantastic, Leslie. It's a really good encapsulation of everything that's gone on in Canada and where we sit. We see a lot of what happens in the United States. That seems to be holding our attention a lot more clearly than it does in Canada, of what goes on in Canada. And I think that's largely because of what you said at the end there, that our politics is just a little bit more boring because it just seems to work a little bit better than some other jurisdictions that we might notice. So, but again, there's still fights to be had. There's still battles to be won, and to make our society a more fair and equitable one. So I appreciate your encapsulating those for us today. Now, the next thing we'll go to today is we would like to take